Thank you for joining us today. Today's webinar is Preparing for Mediation from Selection to Presentation of Claims. My name is Jeff Zano, and I'm your moderator today. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. Slide 8 provides a summary of the series, and Slide 7 summarizes this episode. Speaking of the slides, you should understand from the get-go that we may not step through all PowerPoint slides today, nor will we have you listen to us read the slides. This webinar is like all Financial Poise webinars. It is a conversation that we want to have with our panelists today. Keep the PowerPoint handy, though, because I will try to indicate from time to time what slides our conversation is touching on as we proceed, so you can take notes. Please note slide 5 has our disclaimer. Please note that our PowerPoint is for informational purposes. It should not be considered for legal, financial, or other professional advice. Okay, today our panelists, we have Leslie Burkhoff of Mort, Hock, and Hamroth. Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is the former co-chair of the firm's creditors' rights and restructuring department. Also joining us on the panel today is Elizabeth Champnoy of Champnoy Dispute Resolution and Management Services, Inc. Liz is an attorney, consulting expert, independent full mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of alternative dispute resolution. Also, Liz formerly was in my position as vice president of the AAA a long time ago. How many years ago was that, Liz?
20 plus.
20 plus, okay.
Thanks for reminding me.
Then we have Byung Saw, okay, of Snell Wilmer of Denver. Byung is a business litigator who represents individual clients in complex intellectual property and commercial matters, and his clients have sought his guidance in dispute related to field business ventures and disputes among business partners, shareholders, and directors. And me, well, again, my name is Jeff Zano. I'm the vice president of the AAA ICDR Commercial Division. I'm also an attorney. Feel free to read through more about this panel on slides 33 through 36 at the end of the PowerPoint. This webinar is a production of Financial Poise. To sign up for a great free weekly newsletter, go to financialpoise.com/subscribe/. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get an answer to you shortly. Okay, now let me turn to our sponsors. 1 second. Okay, we have 3 sponsors on slides 3 and 4. We have Mood Online Dispensary. Okay, and then we have Sunburst, maker of #1 typing app for education, and #1 app, and then Max Asset, restructuring and insolvency professionals. Okay, so let me move to slide 11. Okay, and we'll get started with preparing for mediation from selection to presentation of claims. And slide 11, I will turn to. And Byung, that's Byung Suk. What is mediation? Can you talk to us about comparing mediation versus litigation first, and then comparing mediation versus arbitration?
You bet. And my understanding is a lot of the audience may not be well versed in the law. So I apologize for people with legal experience or attorneys that may understand this. But basically, what typically you see on TV for civil cases, where you have a court, you have a judge, 2 parties suing each other. It's a wide open in the sense that's fully accessible to every citizen across the United States to basically initiate a lawsuit and participate in it. It involves oftentimes discovery, which includes written discovery, demands for information, and depositions, and then hearings, and then trials. Mediation is not litigation. Mediation is a way to resolve a matter that avoids litigation. Litigation, you go through trial, and whether you have a bench trial, a trial to the court, a judge, or a jury trial, you seek a judgment which you ultimately try to enforce on the other side. And of course, when you're on defense, you're trying to avoid that judgment, and vice versa when there's counterclaims and claims going back and forth. The goal of mediation is to reach a mutually agreeable resolution. That can be in many forms. but it has to be something that ultimately results in a settlement agreement, and typically a release of all claims and a way to kind of for two parties to end the legal dispute and waive any potential legal disputes going forward. It is not, unlike litigation, which can be forced upon you. Mediation is typically by agreement of the parties. So both parties have to agree, or sometimes a court, and when you initiate litigation, sometimes the court forces you to seek mediation before proceeding to trial. So litigation is not mutually exclusive mediation. And oftentimes, when I'm asked to represent a client in a lawsuit, we will participate in mediation, and sometimes more than one, during the course of a lawsuit before we go to trial. And just so you know, mediation technically can occur at any phase of the dispute, pre-lawsuit, during the life of the lawsuit, and even sometimes on appeal. I've participated in mediation to resolve a dispute, just so that we can finally end for our clients the legal dispute. Those are the primary differences that I can think of. There's no discovery, meaning that's required for mediation. You can conduct discovery through litigation and use the information provided for mediation, but it's a very different format, and hopefully it reaches a resolution short of a trial where you can conserve a lot of money and avoid legal expenses that primarily benefit litigators like me.
Sure. So now what about mediation versus arbitration? I see a lot of confusion in the market sometimes. People think that mediation is the same as arbitration. It's completely different. What are your thoughts?
That's right. That's right. And I think that confusion is legit, because oftentimes we lawyers just refer to alternative dispute resolution as a broad term, which includes mediation and arbitration. So people kind of get confused by, oh, okay, if it's the alternative, they must be kind of the same. The shortest explanation is arbitration is almost a private form of litigation, meaning instead of a judge, you have an arbitrator. That arbitrator could be a retired judge or an experienced attorney, or even non-attorneys, depending on the dispute and depending on what the parties agree to. The similarities between arbitration and litigation are fairly broad and fairly, there's a lot of them. Instead of having a trial under litigation, you have a hearing under arbitration. That's with an arbitrator. You don't have a right to a jury. You don't have juries, period, in arbitration, whereas you can have it in litigation. So beyond that, and the lack of appeal rights that you have after a hearing in arbitration, everything else could be the same. You could have discovery depending on which arbitration provision says or what the parties agree to, and motions practice, which is unfortunate, because it can get just as expensive to participate in arbitration as litigation, depending on what the parties agree to and what the arbitration provisions say. So when it comes to the relative difference between mediation and arbitration, it is the same as the difference between mediation and litigation. I would say arbitration is a private form of litigation, and that's probably a good shorthand way of recognizing the differences.
And do you still see people treating arbitration like litigation? I mean, it seems very common still to this day. It drives me crazy.
It does. And I hate to say this, because some of my transactional colleagues will hate this. I think it's because we don't put that much thought into the arbitration provisions that we agree to.
Yep.
And so
absolutely.
It's so broad, and most litigators coming with the experience that I do, we get so nervous about not having the right information. So a lot of the default, and I can see Leslie chomping at the bit to say something, a lot of the default for attorneys to say, I want the same discovery, which makes it just like litigation, which
Sure.
I hate. Yeah. I mean, you have to have two confident litigators on each side of an arbitration, and ones who are willing to be creative to do it efficiently and make it more cost efficient for the clients.
Right.
And if I can chime in for 50
Absolutely,
seconds, because
Leslie.
this isn't the arbitration program, and for those that we'll get to some of that stuff in another section, but I'm going to add just two thoughts. And Jeff's heard me say this before, so it's beyond probably Liz. At the end of the day, if people come at the end of an arbitration and go, oh, it took just as long, it was just as expensive, I have two comments. Either your arbitrator did not rein the matter in, or cannot always blame the arbitrator. The parties themselves came to it as if it was a full boat litigation. And so at the end of the day, it's always the party's process. But as an arbitrator, I will say to them, you are not treating this like litigation. You are not supposed to treat this like litigation. It's supposed to be faster. It's supposed to be more focused. It's supposed to be more concise. And someone said once, he said, you know, when people make these ridiculous requests, what I'd love to say is, can your clients sign off on this? Because when they complain at the end of the day, it costs as much as a full federal trial. I want to be able to say, your counsel insisted on 45 depositions, interrogatories, notices to admit, etc. So as an arbitrator, I will always try and rein it in, make it focused. I'm not saying parties shouldn't get what they need, but really figure out what it is that you need. And remember, the rules of evidence and the rules of federal civil procedure, a state court don't 100% apply. And I'm making a decision differently than when I would, if there was a jury or a full, or a full bench trial here. So things may come in very differently, and I'm going to weigh them out and determine them. And that, I think, gives you greater flexibility and perhaps should channel the requests you're making. So that's a whole lecture by itself. But those are usually the contributors, is somebody hasn't done what they should have, and it could be a combination of both.
Absolutely.
And we have two lectures coming up in the future.
Yeah, 2 lectures on
So you
arbitration.
can come back and sing us on
I'll go over
those,
those.
so we can get into it.
Yeah, I'll go over those dates at the end. So we're going to turn to you now, Liz. How does one know if mediation is appropriate for him or her? How do you know?
So I'm a big fan of mediation, and I feel like I've dedicated my career to it. So I may be a little bit biased, but I do think that mediation is right for the majority of cases. The only types of cases that you would not mediate would be, disputes possibly involving things like domestic violence or criminal actions. But the majority of commercial employment, community-related disputes, can and often should be mediated. The reason for that is that we know that statistically that the majority of cases do settle. Very few cases actually go to trial. Very few cases go to appeal. And the reason given for that is that we know, based on what Beyonce said and data, litigation, arbitration, very time consuming, also very expensive. So people look to save time and save money by going through the mediation process. Couple of other benefits of the process you should keep in mind to determine whether it's right for you, and we'll talk later about when might be the right time to mediate. In addition to saving time and money, there's also an emotional toll that any conflict has on us. And sometimes people will say to me, well, Liz, in business to business disputes, there's no emotional toll. That's simply not true, because businesses are made up of people. And when people are involved and there's conflicts, of course, there's going to be an emotional toll that is taken on those involved. There's also a life interruption, a business interruption when you're in conflict. So mediation can help to avoid the time and cost, as well as the emotional toll, life interruption, business interruption. Another thing to keep in mind with mediation is that you have the opportunity to have control and certainty in the outcome. When the parties come together to come to a resolution, solve the problem together, oftentimes, right, you have a control and certainty. And outside of the mediation process, you have no control or certainty, right? A court, arbitration forum, somebody else decides what happens next and when. And mediation also provides the opportunity to avoid court, to avoid publicity often, to have the opportunity to be heard in a safe space. What you say in mediation won't be used against you going forward. And so these are just some of the things you should be thinking about is mediation appropriate? What are you hoping to accomplish? Do you have somebody opposing you on the other side who's engaged, interested in coming to a resolution, and wants to sort of reap all of the benefits that I just mentioned? Now, you don't need to have a written agreement to come to mediation. So, oftentimes cases come to mediation pre-dispute. Nothing's been filed. Maybe somebody sent a demand letter saying, hey, I'm going to sue you. Let's talk. One point I want to make is that it's not a sign of weakness to ask to mediate or to suggest to mediate. Years ago, it used to be a sign of weakness. If I want to come to the table, I want to try to resolve it. Maybe I'm admitting I did something wrong. It really is not any longer a sign of weakness. Mediation is very, very popular and became even more so during the pandemic because people could come together more easily. So I keep saying mediation it was very popular, but became on fire in starting in the pandemic and has not continued. Sorry, my camera froze. I think I'm back, but I think you could hear me. So you don't need an agreement per se to come to mediation. There are a lot of arbitration clauses or contracts that have dispute resolution procedures. So it might say if we have a conflict, first you go to mediation, then you go to arbitration, or first you go to mediation, then you go to litigation. So it might be in an agreement. That's something to keep in mind. You may have to mediate as a condition preceded to taking another step and filing a claim. But if you don't have an agreement to mediate, you can still agree to come to mediation, and mediators have, and parties can draft their own agreements that govern the rules of the process or what you're going to do. And every mediator, of course, has details in terms of what's going to be bound by what's confidential, what the process will entail, what the parties will do, and so on. So whether you have an agreement or not, you can still come to mediation and develop that process as you go forward.
But are you seeing more step clauses, like you mentioned, that's in the agreement? I'm seeing more and more of those in the last 5-6 years. Yeah. Very common.
Very common, and good ideas, because I think it originally it started out as that sign of weakness. People didn't want to say to the other, let's mediate, it would seem weak. And so people, the default was, let's put it in an agreement, say, let's go forward first and do this. And it's successful. It's successful. And so that's why I think you'll see more of that to continue.
Yeah, and in 2000, a few years back, about 10 years ago, we put it into our rules. As you know, our commercial rules have a provision, Rule 10, where you have to do mandatory mediation. It's not really mandatory, the people have to agree, but people are buying into that more and more, which is great. Okay, Leslie, I'm turning to you now. What types of disputes are appropriate for mediation?
Any type of dispute.
Any, just like Liz said.
So here's the answer. I say any type of dispute, but I'm gonna shade that a little bit. So that doesn't mean that every type of dispute. So even though every type of dispute could be mediated, it does not mean that in certain cases it's appropriate. All right. There are ones where, look, there are ones that get mediated even if there's a sexual assault in terms of the employment type of issue. So those seem to not sound like they'd be mediated or could be mediated, but they can be, but you're not putting those parties in the room together. So I've done everything from defamation cases to breach of contract to billing disputes to restructuring competing plans, clawbacks, etc. The answer is there's, first of all, the willingness to reach resolution is always the most helpful. So anytime the parties think, gee, if I only could have somebody help us along, we could get it resolved. Perfect. There are those, of course, that the courts are just ordering you to. So not just because of COVID, but otherwise a fair amount of courts, whether there's a backlog, an overwhelming number of cases and a shortage of judges or other reasons, courts are referring things to mediation. There are underlying clauses in contracts that require mediation. They could be med-arb clauses, mediation, and then arbitration. But the answer is, I think any case can be mediated. And then the question becomes, is it the right time? When should we mediate? When should we not mediate? And again, the answer is, and I hate to sound like a lawyer, but I guess I am one, it does depend. So there are plenty of cases that I mediate where they are early stage litigation. And the answer is, depending on the case and depending on what the question is, you can mediate it, because if in that case it's a pure dollar and cents, very narrow issue, and the parties are either sophisticated enough or aware enough of the fact that, you know what, we know enough to know that it probably could get settled, or somebody can facilitate it, and economically, a business purpose wise, or whatever it is, we have enough information, those can still get resolved. Sometimes in mediation, as a mediator, when they're early stage, I'll ask the parties to exchange informal discovery, give some information, not maybe take a deposition, but more importantly, they claim they have offsets to your invoices. They claim that there's some damages here. What if they were to show you, X and Y, or they have an analysis done? In the restructuring industry, in the bankruptcy where there's clawbacks, we can get to the heart of a typical clawback by saying they claim all of these claims of preferences or fraudulent conveyances. Why don't you give them the information on your date range for your ordinary course analysis? And why don't you come up with a little bit, and I bet we can get to the heart of the matter. And so sometimes it's early enough. Sometimes the right time is motion for summary judgments filed. The court hasn't had a hearing and hasn't ruled on it yet. One side may not. I just resolved one the other week where only one side moved for summary judgment. And by that, I mean the initial motion was out there. There hadn't been opposition, but the issues were crystallized. And I was able to get enough information to get the parties to the table. And sometimes it's literally on the eve of trial. Or it's after the court screamed at everybody and made some ruling that puts things at risk. So there is not one size fits all. There is a good mediator will be able to work with parties who can provide some level of information in an intelligent fashion. And quite frankly, sometimes even if the parties aren't well-educated, and I mean well-educated in their facts, or well-educated in the elements of the law, sometimes it just makes sense to settle it, regardless of anything, if you can get
Sure.
to a number. Because at the end of the day, sometimes it could be the cost of doing business.
Sure. Great. Well, thank you. Okay, Byung-Suk, we're going to turn to you now. Finding out whether or not we have enough information for mediation. How can we get information from the other side before mediation? You can tackle that issue.
Yeah, thank you. And to answer that question, I think there's two scenarios that we have to address. One, if there is pending litigation and you're compelled to participate in mediation by a judge's order, oftentimes most parties agree on when's appropriate timing based on information we can exchange or compel from the other side. So sometimes, and I hope, and for those non-attorneys out there, I apologize for using some inside baseball terms, but we have what's called discovery that we mentioned. And typically the court sets an end date for that discovery. And oftentimes within litigation, mediation occurs after discovery, what we call a cutoff or the deadline. That way we have all the documents we've requested and all the deposition transcripts, and then we can participate in mediation. So that's typically generally the approach to it. However, I would say if you have an idea that you already have enough information, sometimes you don't need the discovery. Why incur the cost of that? So ask for early mediation and go through with it. Now, when there's no litigation, you're participating in mediation pursuant to a mediation provision within a contract that calls for it prior as a condition to be satisfied prior to filing a lawsuit, then you need to know, unless there's something in the contract that requires an exchange of information, there's no obligation. So you get creative. You can basically use third-party sources. In a few of my cases, we've hired private detectives because I should say private investigators to get some information. But typically what I've done is I've actually, if I know the opposing counsel, we get on the phone and I say, hey, I think to make mediation work, and we both want this for our clients, we need to exchange some information. Here's the underlying, let's say I was representing an engineering firm. Here's the underlying, invoice data that goes to the services my engineering firm responded to. Before we participate in mediation, I invited them to literally ask me questions to pass on to my client so that you can be informed. And so we've had that discussion. That really engenders a lot of trust to the other side that we were invested in the process. Doesn't mean I'm taking any less of a position. So it was really welcomed. We resulted, especially in most lawsuits, this is going to come as news for people who've never participated in lawsuits. In civil actions, there's no right to attorney's fees in general, at least not in most jurisdictions. I think Alaska, I know there's some fee awards depending on the claim and how it's postured, but most jurisdictions, you do not have a right to attorney's fees unless they're in the contract or some statute provides for it. So early mediation is great. The other way I'd like to sometimes get information, if the other side's not willing to voluntarily provide it, is I send a demand letter, and a demand letter is jargon for settlement proposal, but plaintiffs, we call those demand letters because obviously they're making a demand for payment typically. So sometimes I send a settlement letter saying, this is how you need to resolve it, or you're going to face litigation. And I don't do a short one. I do an extensive one that provides information. That usually invites the other side to respond in substance and not just to the settlement demand. Let's say I demand Leslie pays me $100, and if I put in all the facts that I believe, Leslie's attorney will probably respond to me saying, you're not getting $100 because of these reasons. Boom, 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 boom. That arms me with information to go to mediation. So there's creative ways to do it.
Sure.
But my preference is to have actually agreed upon approach with opposing counsel.
Great. Well, thank you.
If I could just add, because I think it's important to emphasize this. When I was litigating, and I know people, my co-panelists are still litigating. I'm no longer litigating, but when I was litigating, you would do all this discovery, as Beyond Sooks mentioned. You'd have hundreds, thousands upon thousands of pages, files, etc. And the reality was the case came down to a few key critical documents and/or pieces of information. So oftentimes people say, I don't have enough information, I have to go forward. If you're going to go forward, you're going to litigate. You're never going to have every piece of information until you litigate. You're not going to know everything until you're at appeal, right? And there's been a determination and there's an appeal. So it's the balance of the cost and time savings, and this notion that we don't have enough information is just it's wrong. It's a misconception, because you're never going to have that information. Like you said, there's certain key pieces of information. Maybe it's a document, maybe it's a damages calculation or evidence of loss, things like that. That's what you really need, because the rest is an unknown. Will be a factual dispute. You don't know how people are going to testify. You don't know what every record's going to show. And I think oftentimes clients, in particular, lay people, non-lawyers, are thinking there's some smoking gun out there that I'm going to find, and once I find it, I'm going to get the other side. That's just not the reality. So I think it's important to emphasize that information should not having all of it should not be something that stops people from going to mediation. You can get something, as Beyond Sooks mentioned, that's key, critical, that will make that productive.
Sure.
And I would just, go ahead. I was just going to add to Liz's comment that in my experience, and more than 90% of my cases settled, just so the listeners know, in my experience, when it comes to the number of documents needed to do mediation, when it comes to liability, she is absolutely right. There's only a handful. The only times that I see that we need a lot of documents is when we're trying to understand potential damages analysis. That's probably the only thing sometimes we have to figure out, because maybe it's only after we get invoices from the other side and tally up their, counting and doing that. But beyond that, when it comes to liability, meaning who may be potentially exposed to a judgment, that's usually a handful of documents. When it comes to how much that judgment may be, or that we may pursue, that's kind of where you get more than a handful of documents. But in many cases, I completely agree with Liz.
And I was going to say, we'll tuck into this, and I don't know if it's our second or third one, but there are things that you can do to use the mediator to help identify the thing you have to have. And again, I'm not suggesting mediation should be used as information gathering for other purposes, but it is not, as I mentioned before, foreign to the process. And if something really is critical, if you had to say to them, look, I can't decide this, or I can't respond because of X, the mediator will help you figure out, do you really need X? And if X is an impediment, as a way to get X so that everybody can make a decision.
So Leslie, I'm going to turn back to you. Can we force the parties to mediate?
Well, the answer is apparently yes, but whether it's a good idea or not. So, as I indicated previously, mediation has become a big push. Again, pre-COVID a bit, post-COVID a lot, during COVID hugely. A lot of state courts, federal courts. So in New York, we have something called presumptive ADR. That's a nice way of saying mandatory. You have it at the appellate court levels. I sit as a mediator in all of these different ones. In the restructuring courts, anybody that's been involved in a large bankruptcy, they enter procedures orders at the outset of cases where you are required to comply with mediation. I sit as a panel mediator on a host of cases, and that's part of the process. The courts do have the ability to require parties to mediate. Now, whether or not somebody willingly goes into it, that's a separate question. However, and I have only dealt with this issue where I've had to sort of report back on lack of good faith, and I stay very far away from it. It was exigent. The one time I had to do it, it was a real problem because of who they sent and how they handled it. But, you know, the fact that somebody doesn't cut a deal, the fact that somebody doesn't want to cut a deal is not good faith, but inherent in almost every order is you need to engage in this in a good faith capacity. So the advantages and disadvantages are, look, sometimes the advantages are this. When a court sets it up because it truly believes that the parties should be focused on resolving it and can truly issue spot wad, and has perhaps set it up in a way that they've sort of hit everybody in the head and said, there's risk for you, or there's a decision that they've issued that puts some things in play, or the court is so clogged up they're never going to see the light of day to get to a decision, then there is a true advantage here. If you listen to the judge, you know, I worked for a judge a million years ago who, when he wanted people to settle, would kind of do an oral argument with them and say, you have risk, you have risk. He'd pull them in chambers, yell at everybody, and sort of let them know nobody's going to be happy with what happens here, figure it out. The disadvantage is when courts blindly send things to mediation because they either don't want to deal with it or just doesn't have time and just sort of says, hey, you know, she'll make it go away, and it's not ripe. And remember, we said you don't always have to be right, but I mean, it's just not right because the parties don't have enough risk or it's just too early in the case. It hasn't been focused. That's a disadvantage. When the parties truly are unwilling to participate in the process and there's just too much animosity, or again, maybe just not enough information because the complaint and the answer are just, they're nothing. They're cardboard little outlines. There may be nothing to work with. So I will tell you, you know, look, as a good mediator, I don't always assume that because it came to me here, there, or anywhere. I will have pre-calls with the parties. There are things that I do to try and assess it. And I will send people back to the drawing board and say, look, I need you to look at this. I need you to answer that. I settled one a week ago where I was really concerned that one party had not focused on stuff. And I didn't have enough information and they hadn't looked at it. I was able to do some things that made it happen, which was great, but timing can be everything. The next is, and Liz, you tipped into this, I think, a little bit on your beginning, but I'll flesh it out a little bit more. If we can go to the next slide, Jeff, is how do you get the process started? So obviously there's the court sending it. So the court just says, hey, you're going. That just is what it is. The next is a request or a demand. And people are like this. If I request mediation, am I weak? Do I show weakness? And I don't want to request it because they'll think I think I'm caving. There are ways to put that together. There are ways to do it that sort of says, hey, look, I think I'm going to kill you in court, but, you know, I'd like to not spend money on this. We got a lot of better things to do. We're only so far apart. What do you think we bring somebody in and just see if our clients can get in the room? But there is always that fear, as Liz said, of I'm showing weakness. I'm just not whatever. There's also ways to get the judge to do it if you don't want to be weak. And you have a chambers conference and say, look, judge, you know, not ex parte, you know, I'd like to, we think we can get it done. Can you get us to a mediator? Because sometimes it's the parties. Is there an obligation? So put aside the court sending you, your underlying agreement could have a meet-or provision. I had one of those recently where we were obligated to go to mediation before the arbitration could go. It was embedded in the party's contract. That was it. Other, for example, AAA does have, even if it's just a straight ARP clause, you do have the overlay that says to people, you know, don't forget, there's a way to do it by mediation too. You can move on parallel paths.
You know, can I ask you a question on that? Do you
Yeah.
like to do that with simultaneous parallel tracks to keep the arbitration process going or not?
Those actually are almost problematic
Okay.
because the
How so?
problem I have is they're wearing too many hats and they're serving discovery, and then maybe the mediator's getting them focused, and suddenly they're like, wait, look, I have what I think is a smoking gun in arbitration. So
Good
I
point.
like a parallel path that's staged, which is, here will be your arbitration dates. Here will be your discovery schedule, but you're going to focus on this first. and it's hanging over you. I hate to say it that way, but it's there. But two at the same time, I need them to wear different hats for mediation, and it's not the litigator's hat.
Yeah. I
So
see.
that's a
Good
little
point.
bit problematic to me. I've done it. It just doesn't always work well. And then the
Sure.
other problem is, if the mediation isn't successful and they're sort of in the arbitration at the same time, I always get the way, I didn't really mean those were my discovery demands. I have a whole other set I'd like to trump out now that we haven't settled, because I only stuck stuff out because I figured we were settling it in mediation. Now I
Yeah.
gotta start over. So to balance.
Have you ever had your arbitrator become your mediator?
Okay, so I have very specific views on this one. You've heard me. Yeah, you can do it the following. I believe you can be an arbitrator who can then become the mediator.
Sure.
I do not believe you can do it the other way. Once the curtain is down for all purposes. So as an arbitrator, I am hearing evidence. I'm sitting as a judge, if you would, and I see what I see. I make decisions and I move forward. And granted, it's not quite the same rules of evidence that you get in a courtroom, but I'm still running a process. In mediation, people are sharing with me privately stuff that may or may not go to the other side. And I then have seen behind the curtain, so to speak, and I can't unhear that bell. I know that people have said, well, it's okay. Let the parties just waive it's not really a conflict, but waive the issue. And the answer is, trust me, at the end of the day, if I've mediated and now you want me to arbitrate, and even if I say, I swear I'm going to forget everything, or you people have cleared it, the minute I rule for Liz, Bjornsk's going to be unhappy with me. And he's going to say, well, you know what? I told her X and she knew X was an issue. And even though Liz didn't know X, she had that in the back of her mind and they're going to challenge it. So I'm very uncomfortable with that. I just think it creates way too many issues. I think the only way you could maybe switch gears, if really nothing's happened in one capacity or the other, maybe. So, you know, you've mediated it and nothing ever happened. In other words, they literally sent you initial joint statements and said, forget it, we should arbitrate. So you've never seen the private, but I don't want the risk. That's
I mean, look, if there was no private caucusing, wouldn't that be okay? Or not? Still no.
The answer is, if there's no private caucusing and nobody sent anything to me privately, but I do private calls with the parties ahead of time.
Sure. Okay. Yeah.
I don't
Very,
want the risk.
very unlikely not to have. I mean, the benefit of having the mediator is to have that private caucus to speak freely, openly for the mediator to best help. But
Liz is right.
I guess there could be an instance.
But it's rare, and I don't want to argue that it never happened.
Okay, so Liz, we're turning to you now. What should you expect from the mediation process?
So,
selecting a mediator.
Yeah, I think it's selecting the mediator is more what we want to talk about here, Jeff. I don't know why it's labeled the way it is. We'll fix it for next time. Selecting the mediator. We're at the stage, you've agreed to come to mediation, everybody's in agreement, however you got here. Now it's time to select the mediator. Very important step in the process. A mediator can really make or break the case, and a good mediator can be responsible for the settlement, right? And a bad mediator can be responsible for the case not settling. So keep that in mind. It's really important to select, the best mediator. Now, not all mediators are right for each cases. I predominantly do employment. When I get a call on a personal injury or a construction or something, divorce, I say, no, it's not my area. It's not what I feel comfortable with. And people say, yeah, but I've had you in this situation. I thought you were great. Just because you're a good mediator and or trained in the process does not necessarily mean you're right for a particular case. So a couple factors, and if we could advance to the next slide, Jeff, a couple of things you want to consider. You want to consider subject matter expertise. What subject matter expertise is needed for this particular case? Personal injury is very different from employment, is very different from construction, right? Other areas, generalized commercial, accounting, etc. People can easily go between, but certain areas, certain conflicts have trends, norms, expectations, laws that an experienced mediator that has that subject matter expertise is going to be critical for. And you'll know in the process if that mediator has that expertise or not. If, certain things that are common to the practitioners are not common to the mediator, then they probably don't have expertise in that area. I'll give you an example, which is one is in employment. I had a case recently where counsel was saying, I was saying, well, how will the allocation of the payment be made? Back pay, emotional distress. And we had a 3-hour conversation about emotional distress. Emotional distress is very common in employment cases, but this person had tort experience and less common. So that kind of distraction with somebody who doesn't know a certain area of the law can add time and cost and lead to, a case that doesn't settle. So you want to think about subject matter expertise. You want to think about their background, their history. Have they been a litigator? Are they going to be able to evaluate the case from a litigation perspective? Is that important? Have they been a transactional lawyer? Does this really come down to how the industry works and how transactions are put together? What knowledge do they need? What background? You want to think about their personality. You want to think about who they're going to connect with, who they might offend, right? Because your personality and the person you select does not fit for every case. You might even think about things like their styles. Some mediators are very facilitative, meaning they want you to sit together, they want you to talk it out, and they sort of facilitate that conversation. Others are much more evaluative, where they'll say, listen, here's your weakness, here's your risk. This case should settle for X. You want to think about what it is that you need from this mediator. What does this mediator need to do to help get it across the finish line? Sometimes people will call me and say, when I do my pre-mediation work, as Leslie does as well and is mentioning, they'll say to me, I need you to convince my client of X, right? Or I picked you because I need you to explain to the other side their risk in this. And so you're thinking about who it is that you need. You really want to think about, what do I need that mediator to do? Who do I need them to persuade? Who do I need them to win over? Do I need them to have a judicial background, to be a judge, so that they have the gravitas, so to speak, to come in and tell my client what needs to happen? These are just sort of high level things that you want to be thinking about. You also want to be thinking about sometimes gender, in a sexual assault. Leslie mentioned a sexual assault, sexual harassment. Sometimes you want a woman. Sometimes you don't want a woman, right? Sometimes you want somebody with a different demeanor. So there's various things, that you have to think about. It's not just looking at a resume. It's almost like selecting a juror in a way, in that you need that person to, you want to know their feelings, their thoughts, their views, because they're going to guide that process from, start to finish. And if they lose, somebody throughout because they offend them, or they just didn't connect with them, or, the person doesn't take that, that person seriously because they didn't go to an Ivy League school. There could be so many different things that you're thinking about. So I just want to emphasize, it's really not look at a resume, find somebody who's experienced. You have to understand your case. You have to understand what you need from the mediator. You have to understand the players, who's involved, who's going to be at the table, who's on the other side of the table. So many factors in terms of having that person help you and guide you through. Now, how do you find a mediator? And I think because we're running short on, you don't want to just pick from a list per se and look at resumes, bios. You want to ask around. You want to talk to other lawyers or people who have used that mediator to ask questions. You might want to call the mediator. There's no reason you can't call a mediator. Like, you can't call an arbitrator, can't call a judge, right? But you can speak ex parte to a mediator. So you can call a mediator and say, hey, I want to pick your brain. I want to give you high level experience in the case. Have you handled cases like this before? What would you do in this situation? And run things, by them. So the other final point I want to make real quick is sometimes people will say to me, well, they picked you, they insisted on you. That's not necessarily a bad thing, right? If somebody, particularly the paying party, if somebody says, we want so-and-so, oftentimes the immediate reaction is, no, why do you want so-and-so? No, I don't know them, or I haven't worked with them. They're going to favor you. No, oftentimes it's that if somebody's saying, I need this person, it's because they've worked with them, they know, they trust, they're going to tell them like it is, right? Mediators are not, looking to get more cases by, sort of siding with one side. the way successful mediators get cases, they do a really good job and they tell it sort of like it is. They provide the reality check. They give a real perspective as an outsider looking in. So you shouldn't worry if somebody says, if your opposing party, counsel, whoever says, I want somebody in particular, you should still do your due diligence, but it shouldn't be a knee-jerk reaction of, no, I don't want that person just because you do. In mediation, it's particularly helpful because it's usually a sign that there's trust, rapport, and they're going to listen to you when you're telling them what they need to do, and even if it's not what they want to hear. I know others want to jump in and we want to move forward, so I'll stop.
Well, I just want to say, you've seen the videos that AAA ICDR does for mediators. I think those are very helpful for someone to see the demeanor of the mediator. I think it really helps out a lot.
I'm gonna add a 1-minute comment because I'm mindful of time and we still have a lot to cover. And I think, Liz, you've unpacked everything. The one thing that I see people so many times go, oh, he or she was amazing in the last case, I'm going to use them again. One size doesn't fit all. Even for me,
Good
or
point.
Liz, just the answer is yes, we are awesome. But there are cases that we may not be the most effective mediator in that room for that case, for that purpose. So
Sure.
I don't think I need to say more than that, but you got to think about that.
Okay, Young-Suk, let's go talk settlement.
Yeah, I mean, as that slide indicates, the question is, should we offer settlement before mediation? The short answer is, I'm a big fan of a round of settlement discussions prior to mediation. Not only because it sets what we quote unquote call the floor or the ceiling, and in our field, the floor is basically the lowest a plaintiff usually demands in money. The lowest basically the defendant will offer to pay a plaintiff to go away, and the ceiling is the highest demand that typically happens. So that's kind of the terms that you'll hear often lawyers use. But beyond those, setting a floor and a ceiling on the money that's at issue, what I like about a round of settlement discussions, especially with experienced attorneys on the other side, is you share a lot of information going back, and that relates to the slide that we had before. When it comes to, what are our goals, I think clients, and those of you on this webinar who are more clients or business people, not attorneys, you need to understand that you need to be as forthright with your attorney as possible because about what your ultimate goals are. Telling me that you're willing to walk away by paying Liz $100 doesn't mean I start out negotiations at $100. But knowing that makes me adjust appropriately to try to meet your goals. And then the mediator helps me understand why that goal in private discussions is valid or is unrealistic. And then we can adjust that goal. And again, to hit on points that Liz and Leslie mentioned, is these are private discussions that we can share with the other side if we want to, but most times we say, no, here's our thinking. I don't want the other side ever hearing about this. But oftentimes sharing those goals with your attorneys and your mediator in the mediation sessions allows for creative next steps during the banter going back and forth between the sides. And then the mediator is usually a great messenger.
Great. Okay, Leslie, turning to you, what will the attorneys do before mediation?
What will the attorneys do? Or what should the attorneys do?
Yeah, what should they do?
So the answer is, here's the way I say it. Okay, so we'll talk go backwards. So when I get selected as mediator, I have an initial call with the attorneys, and it's usually a joint call to sort of set my expectations and tell them how I'm running my process. Okay, this is what I'm going to like to do. This is what I'm going to want to do, et cetera, et cetera. I will talk about the fact that I'm going to ask them to do a shared statement, which I will emphasize, settlement-focused statement. I don't need the history of the law. I don't need a history of the world. This is not going to a judge. I need salient information, key elements, key facts in dispute that will let me understand what the issue is. And by the way, I don't want to reinvent the wheel either. So at the end of the day, if you have a summary judgment motion and everything's there, you can slap it on as an exhibit and then give me a little bit of an overlay on the settlement focus, but I want them sharing it. I'm then going to ask for a private statement as well, just for myself, which I'll get to in a second. One of the things, and I just don't remember if we'll cover this or not, but I'm going to say it, is in doing this statement and how it's different from what's going in front of a court, is you really should be understanding your issues, your facts, and your claims. And you should be analyzing them with some level of risk analysis. And I understand, because I'll talk about, let me just folds it in, that I get into confidential, my eyes only statements. So I basically say, please share these with each other. Please educate me, because you've been living this dispute for however long you've been living it. And again, I don't need the history of the contract law. I need, if you're telling me that you believe that there is a defense to the claim, or that they haven't made their elements, zero in it. String cites are meaningless to me. By the way, judges hate them too, but everybody thinks they want them. Okay. I don't want them. I want the salient case, the salient law. Then once you've gotten those, each of you give me a confidential, my eyes only statement. Obviously everything's confidential, but I mean just me. View it as a rebuttal, view it as a reply, view it as telling me the stuff you don't want the other side to see. But the more you share with me, please let me know if your company's at financial risk. Please let me know that the two principals hate each other. And if I put them in the room together, and by the way, I'll do other emails that will ask about this, but tell me where the smoking bombs are, that, you know, so that, because I'm going to form a trajectory. I'm going to start a path in my mind of where I see things. And if putting Bob and John in a room, or Sally and Bob, is going to explode the world, someone better tell me that. Okay? Because it is confidential to me. I'm here to help you get to a result. Help me help you. So that is super, super important. And then the last thing I'll add to that, and then, you know, is when they and by the way, tell me the last offer that was exchanged. Tell me where you're thinking settlement. I know nobody wants to tell me exactly what it is, and I get it, because they think I'm going to walk into the other side and say, hey, great news. Liz said 20, just give her 20 and she's out of here. It's not what I'm doing. But if there's something else you need or want, because the benefit of mediation versus a court decision is this. When a court makes a determination, it's black and white. The law says X, you either win or you lose on whatever claims they are, and they can go either way. In mediation, you can craft a resolution. So even if Byung-Suk owes Liz $100,000, let's just say what he really needs is, I'll give her X, a bit of X. But you know what? I don't really want to terminate my business with her. And if she could just give me a better percentage price off my products that I'm buying, I'm very happy. And we can fix this. I'd like to do business with her. So we can trade things. This is horse trading. So if he needs X or he needs Y, or by the way, I can give her a piece of this, but she knows Sally, and I've really been dying to get into Sally's business. Maybe she can do that. That's where you make these asks. Tell me what it is you really need.
Sure. Liz, what are your thoughts on communication with the mediator?
I think it's very important, and I say this to parties or counsel, there's nothing that should be held back from the mediator. I think a lot of litigators, I just think that's bad advocacy. Unless you've never worked with your mediator before, you don't trust them, they're new, they're inexperienced, maybe then you hold some stuff back because they might make a mistake. But if you've hired somebody, that is your expert. And so you should be giving them everything they need to know, as Leslie has said, I say arm me, give me what I need to help you. Tell me what I need in the other room. But sometimes litigators, the mindset is, I'm going to hold it back to trial, or I'm going to hold something back till later in the afternoon. And I'll be frank, when that happens, I get very upset, because I say, now, if I had known this 6 hours ago, I could have done something with it differently, and it's changed the course of mediation. And now if I raise it, it's a problem. So share everything with your mediator. Don't hide the ball. I often say, just to add, tell me what the strengths are. Every lawyer does that, but tell me what the weaknesses are. If you are coming to mediation and haven't thought about your weaknesses, you're not prepared, right? Every case has weaknesses. Tell me what your motivations to settle are. Tell me what's going to get in our way on your end or their end. Tell me the relationship between counsel. Sometimes the relationship in this case or other cases helps. Sometimes it's an impediment and it hurts. Sometimes it doesn't matter. But if you can't stand the other side, I want to know that. If you've had a long history and you don't trust them, believe them, they burned you on something, we want to know that, because that's going to help us as the process goes forward. Solutions you covered, the negotiation history. Who are the players? You know, I love when somebody says to me, Liz, somebody's going to be very difficult. My client is going to be very mean to you. He's going to rip you apart. Don't say this to him. Don't say that to her. And don't do this or do this. You know, that helps because you are living the case, or it's you're the party or you're the lawyer. You're in it. You know who we're dealing with. So warn the mediator, good or bad, you know, what they need to do, who's in the other room, what the dynamics are.
Now, I know we're going to touch on this on the next series that we do, conducting the mediation, but just want to see it in the last few minutes that we have, virtual or non-virtual. What are your thoughts on that? I'll go around the table. Youngsuck?
I'm a huge fan of in-person
Okay.
and dedicating and requiring the parties to be there in attendance, or somebody's authorized to make decisions on that person. I've done Zoom before. Some of them have been successful. Many of them I find that the attorneys on the other side, and sometimes me, we get distracted by emails going off and on while we're waiting. And it's bad enough that we have our mobile emails, but when we're in the office, it's even more distracting. So I'm a huge fan of in-person mediation.
That's interesting because we're seeing at AAA ICDR, arbitrations are coming back. Probably we're at 60% capacity now with in-person, but mediations, I would say 80% are staying in the virtual world. So Leslie, your thoughts on that too?
I prefer in person with an exception. I'll give you a quick
Interesting.
caveat.
Okay.
So I prefer in person as much as I can, and I've done everything from in person to hybrid with some people in Zoom and out. The exception being, there are some parties that I have worked with where I know the players, I know it's literally like a discrete clawback action. And I know that maybe if everybody has to come in person, I'm going to lose dollars in the mix to settle it on both sides. I'm not telling you I won't do Zoom, but I also know that there are cases I never, ever would have gotten settled had I not been in the room with them and been able to make a personal connection. You just deal with people differently. You relate to people differently. Body language is different. And so if all things being equal, I want you in person. And if you want to fly me to an exotic location to cover it, I am, for those in the audience, I am completely willing to sacrifice myself.
Yeah. And if you're in the virtual world, you can't provide those nice snacks to the
No, the
clients.
snacks are great. I mean, AAA, you guys have good snacks.
We do.
By the way, and I have a saying, and then I'll let Liz chime in, is never underestimate the value of a well-placed cookie.
Absolutely. No, Liz, I see you a lot in the halls of the AAA in Midtown Manhattan with your mediation. So I kind of know what your answer is going to be, but take it away. What's your thoughts?
I still prefer in person. I was but when the pandemic hit, I said never, no, I'm not doing it. I had no choice based on my schedule. We figured it out. Does it work? Yes. But it really comes down to, and Leslie and Beyonce have covered this, is the commitment of the parties, the attention of the parties, the ability to use the platform. I had to learn how to work completely differently as a mediator when we went to the virtual world. I'll also admit to you, I work so much harder virtually than I ever do in person. It's like 10 times, 100 times harder virtually because not everybody is paying the same attention. There's the distractions, as you mentioned. Counsel and the parties aren't having those conversations when I leave the room, right? They walk the WALK, the dog, I can't say the word. You know, they go have lunch, they get distracted by something else. They're not sitting there together, committed, brainstorming. So unless I much prefer, I understand somebody's in Italy, somebody's in Israel. It doesn't make sense for the carrier to come from Chicago to New York. I get it. They can be virtual, but that commitment level, the attention, the dedication has to be there. Otherwise, you're wasting a lot of time and energy, and you're making the mediator work in a way that is not necessary. Whereas if we had just spent the time together, we would have gotten there sooner. I find less cases, and I don't have stats on it, just anecdotally, the amount of cases that don't settle the day of versus in person is becoming a little frustrating because they do settle eventually. but not that day. Often, more often, I'm finding virtually, unless you have that commitment, because the mediator has to keep working, and it gets done. But had we just been there, we would have saved all that time and money and gotten it done. It's because of
Sure.
attention spans, it's because of dedication, preparation, and so on. So once that's there,
Absolutely.
no problem. When it's not, that's when you're delaying and costing
Understand.
too.
Well, unfortunately, we're out of time, but I want to thank the three of you. You guys were terrific, and thank you for letting me be your new moderator. I greatly appreciate it. And I want to thank the audience, for joining our entertaining and educational production for Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And we hope you will join us for the next webinar. And I'm going to go over this series. The next one is on May 14th, conducting the mediation. Okay, again, May 14th. I think it's going to be at the same time. And then the next one after that is preparing for an arbitration. Okay, and that is June 18th. And then the final one is handling the arbitration, and that's July 23rd. So again, I want to thank the three panelists. You were terrific. And I want to thank Financial Poise. Thank you very much.
Thank you, everybody. See you next month.
Thank
Bye.
you.